Now, following last week's Constitutional Court ruling, Cooperative Governance and Traditional Affairs Minister Dr. Nkosazana Dlamini-Zuma is expected to make a proclamation that the 1st of November will be the day that the local government elections will be held. This along with the 18th of September as the day to hold a final voter registration push. Joining us now to outline the logistical and practical challenges ahead of the November 1st is Executive Chair of the Institute of Election Management Services in Africa, Dr. Tselane. Dr. Tselane, good to have you with us on the Daytime Update today. Now, we are awaiting Minister of COGTA, Nkosazana Dlamini-Zuma, to be briefing the media any moment now, probably in the next 15 minutes or so. And in as much as she will be announcing the new date for the local government elections, there's still a lot of controversy around the interpretation of the Constitutional Court's ruling regarding whether or not there should be a reopening of the candidates list. What is your interpretation of that court judgment?
Well, for now, the Electoral Commission has made its call, and then there are the people who have been tasked with the responsibility of having to organize and manage the elections, and they've interpreted the Constitutional Court order to mean that it allows them to open candidate registration process. However, my opinion is different. I did not understand the Constitutional Court order to be saying. I understood the Constitutional Court order to say that it is constraining the IEC's capacity to act in terms of Section 11 by directing the IEC to basically use the election timetable that it issued on the 4th of August as a basis for any amendment. And then the court was very, very specific when it was saying, in spite of the fact that the Electoral Commission has got powers in terms of Section 11 of the Municipal Electoral Act, they must know that whatever they do is subject to the election timetable that was issued on the 4th of August. And the Constitutional Court further took two aspects from that election timetable. They took the voter registration and the proclamation, and then as a result of that, there is consequence alteration that would have to happen on the election timetable that the IEC is directed to introduce or to amend. So on the basis of that alone, it means that the election timetable as on the 4th would remain, and the only thing that still remains would be the candidate nomination process.
Are you then saying, based on your interpretation, that had the Constitutional Court completely overridden the August 4th timetable, then that would have meant that all the three pillars which you mentioned there, the voter registration, the proclamation of the date, as well as the regulations that drive or that govern the nomination of candidates, that all of those three pillars would have essentially been dismantled. But because the August 4th and the issue of the timetable has not completely been overwritten, there is still one element which is still binding for the IEC, you say, and that element is the element of candidate registration.
Absolutely. You've actually captured it correctly, Tammy, that if the Constitutional Court wanted that aspect to be removed, they would have actually indicated that the election timetable issued on the 4th of August is invalid, and therefore the IEC would then use Section 11 of the Municipal Electoral Act to completely draft a new election timetable.
Talk to us about Sections 14 and Section 17 of the Municipal Electoral Act and how those two sections pertain to the situation that we find ourselves in now and the precedence that has been set in this regard.
Section 14 and Section 17 are so critical in the management of this process. Firstly, Section 14 refers to a political party that intends contesting the election, and it says or directs that that party must submit its intention to contest the election and must submit the following: must submit the list of candidates, a deposit, and then most important, it says by a date not later than the date specified in the election timetable. That is so critical to understand this particular process. So if it says by a date not later than a date specified in the election timetable, it means everybody is expected to comply with. Now, these are two, and the Section 17 says the same thing, but it refers to basically the independent candidates. In other words, those who are going to be contesting the wards, in an election. But basically, it is the same thing, except that Section 14 refers to the political parties, and Section 17 refers to independent candidates or ward candidates.
Tselane, before I let you go this afternoon, obviously, the matter of law is always a matter of, because this one judgment is being interpreted in different ways by different stakeholders. But what is supposed to be the procedural process when there is a misunderstanding of this nature? Is it not to then go to the court that issued this judgment to ask for clarification? Should there not have been an approach of the Constitutional Court for them to clarify on this matter and the details thereof?
There are two possibilities. The first one is to accept the interpretation by the Electoral Commission, because it is the one that is tasked to administer the elections. So if we accept the interpretation by the Commission, it means everything goes according to the way the Electoral Commission has interpreted it. And the second one is to approach the courts. So for the clarification on that particular aspect.
So should this perhaps not even have happened beforehand if there is ambiguity in this regard?
No, unfortunately, there is not much time. And the Constitutional Court only issued its court order last week. And we've been now in debates around what it actually means. And the Constitutional Court has not issued the full judgment. And then therefore, this could not have been done any time early. And then unfortunately, it is putting also the Electoral Commission in a very envious position because, to prepare for the logistics of the elections, you need certainty. And currently, there is no certainty, and it must be extremely difficult for the IEC really to proceed with these elections. And then I don't blame them, because this is not out of their own making. They have been doing these things out of goodwill. They listened to the voices that were there when some of us were saying that the current conditions were not conducive to free and fair elections. They decided to approach Justice Moseneke, who issued a very comprehensive report. They took that report and then went to the Constitutional Court, let alone other reasons of why they went to the Constitutional Court and not Parliament. But all these things were done in good faith.
Tselane, we'll have to leave it at that for this afternoon, but I thank you very much for your time as well as your insight in this particular matter. That was the Executive Chair of the Institute of Election Management Services in Africa, Tselane.